Hey, good afternoon, criminal justice practitioners. Dr. Guidry here. Just kind of wanted to go over something that we've kind of discussed through some of our criminal justice courses, and I kind of want to reiterate that because I've gotten some questions on intent, right? So if you've taken the introduction to criminal justice or maybe the fundamentals of criminal law, even the course class, I may briefly touch upon or upload some sort of video that may be related to something called corpus delicti, which is the body of the crime. And within that, you would have what the guilty mind is, or mens rea, the intent. And then you would have what is called the guilty act, or actus reus. And then those two things coming together, concurrence, which ultimately leads to causation. The end result, what is the crime? So let's look at what intent is, because I think sometimes I may not provide a good enough definition to that, or we're kind of so rushed that I may gloss over it. I may not even mention it, and hope that you go back and look at it and figure out what intent actually is. Well, there's four things we're going to look at in terms of the categories of intent. One is purposefully, one is knowingly, one is recklessness, and the other one is negligent. Okay, so we're going to look at those four right now. If an individual acting purposely, or an individual acts purposely, the goal of that defendant, believe it or not, was to cause the criminal conduct. Okay, so if someone acts purposely, whatever criminal conduct they're engaged in, that is the goal, right? The goal is to have this happen. So, for example, if an individual premeditates killing someone, we hate to talk about that, but we have to talk about that. They premeditated, they planned it, they deliberated, they have malice aforethought towards the victim, whatever that is. And they want that person dead. It's kind of a specific intent crime. They want that to happen. And they are going to plan it and carry it out. And so that individual is acting purposely. Let's say they lie in wait for someone. And when that someone drives up to their place of residency, their business, whatever, person jumps out of the bushes and kills them, right? Shoots them multiple times and runs off. They plan that because maybe this person they allege did something to them, disrespected them, had an affair, whatever. Okay. That individual, that defendant is acting purposely, right? They want to cause the criminal conduct, which is murder. They intend to do that. Now, if an individual is acting knowingly, it's kind of a lesser category of intent, slightly less. In this case, a defendant is particularly certain that the conduct they engage in will actually cause a particular result. Okay, so let me clarify that again. The defendant is particularly certain that the conduct that they engage in will cause the particular result. So, for example, okay, if an individual goes out on a night of the town, goes to some club, some sort of fight or something, argument ensues inside the club, and this individual is pissed off, whatever the case may be, maybe they were shoved out by security, the club begins to close at 2 a.m., and the individual comes back and just starts shooting rounds in the parking lot of the club where there are many individuals who are leaving that club, could potentially be shot and up to and including killed. So for this, that we would say that individual is acting knowingly, right? They know that if they go over there and engage in that type of conduct, right, start just shooting inside a crowd of people, then they are, or we are pretty certain that they know that a particular result will occur, which could be someone seriously hurt or worse, killed. Okay. Now, this person didn't plan it per se. That's how we're going to look at these things in black and white. But nonetheless, they acted out. They did it knowingly. Okay. Now, another thing we could look at is a bank robbery. An individual goes to rob a bank. They bring a gun to kind of intimidate the bank teller. Their intent may not be to kill per se. They didn't plan to murder anyone, but they brought the gun as an intimidating type factor. Okay. And in the process of the robbery, the clerk or the bank teller decides that, they are going to try to stop this, or the security guard may try to stop this. And in the process of that, the defendant gets kind of scared, spooked, whatever, and reacts and shoots maybe the teller or the security guard, whatever the case may be. We would then say that that defendant not necessarily acted purposely, but they sure in the heck acted knowingly, meaning that, hey, you know what? If I bring a gun, even though I don't intend to use it, or I don't intend to kill anyone, if I bring a gun to a bank robbery and I have to take that gun out to commit that robbery, the thing could discharge, I could pull the trigger, whatever, and someone could be hurt or killed. Okay. So it's not saying that the person planned this all out to happen, but knowingly, they should have known that if they decided to partake in that type of conduct by just bringing the gun to the bank, that something really, really bad could happen. Okay. As in extremely hurt or even killed. Okay. So we would say that person, in the grand scheme of things, and I'm not a lawyer, acted knowingly. Okay. Now, acting recklessly is the defendant consciously disregards a substantial or some unjustified risk that the criminal conduct could, would, or may occur. Okay. Again, totally disregarded a substantial and unjustified risk that could lead to some sort of criminal conduct occurring. For example, and we talk about this all the time in my class, is DUI, or OWI, whatever the case may be, DWI, whatever that is, however you want to term it. At the end of the day, we know we're not supposed to drink and drive. However, if we drink and decide to drive from a bar or from our home to somewhere else, whatever that is, we know we're not supposed to do that. But if we drink and do get in our vehicle and decide to drive, we're disregarding a substantial and unjustified risk. We're ignoring everything, okay? And we should know better, or we do know better, but we're ignoring it, okay? Our intent's not to go out there and run somebody over or even kill them, but nonetheless, we know we're not supposed to do it, yet we did it. And along the way, an accident occurs, someone dies, someone gets hurt, or they're just pulled over and charged with a DWI. What we would say is that person is acting recklessly. Basically, we're saying, hey, you know what? You thought about it, but you disregarded everything. And you still decided to get behind the wheel and while you were drinking and drive off somewhere where you could have easily hurt or even killed someone. So we say that's reckless behavior. Okay. Now, when someone is acting negligent, we say that the defendant was not possibly aware of the risk, but should have been aware of the risk. So what we look at in terms of negligence, we always look at in a normal situation, how, if that situation was presented, how would a reasonable person under similar circumstances in that situation react? Okay, so what we want to look at there is, one example I like to use is, the discharge of a firearm, right? Removing a gun from your waistband, and you accidentally have your hand on the trigger and it goes off, right? It's not like you were playing around with the gun, but sometimes that does happen, even with professionals, right? Something occurs, they slip, they're not aware of it, the gun goes off. That can be termed as negligent. And the gun hits somebody, either maims them, or in some extreme cases, it does kill them, right? So we would say that individual's acting in a negligent manner. One of the other things that I've looked at over the years, or I've seen over the years, is individuals, new families, who have a young one, their first child, and newborn parents, they go out and decide that they're going to both go to work, and one of them has to drop off the child at daycare. Well, for whatever reason, the one parent who had the child and who was supposed to drop him off at the daycare center forgot. And that actually does happen. It has happened. And by the time they noticed what had happened, then at that point it may be too late, and they go down there, they go back to their car. It's the middle of July and the child's dead. Some people would say, well, they're actually acting recklessly, but there's actually research that shows that sometimes new parents, their routine is now altered to the point they may forget something, and they may forget their child. Now you see car makers and things like that have alarms to say, hey, check the back seat and all that. It's because of all that research and some of these accidents that occur. So we could say that the parent was negligent in their behavior. I wouldn't borderline it on reckless, because to prove reckless, you have to be able to show that the defendant consciously disregarded that risk. So hopefully this helps you when it comes to those 4 categories of intent. We can play with this all day long. Remember, the most serious, acting purposely. Hey, you plan this is the outcome you want to happen at all costs, by any means necessary. And then of course we have the knowingly intent, reckless intent, and then of course negligence. So whenever you're hearing the news or you hear them talk about what the intent of the perpetrator was, try to think of those 4 categories and where they fit. I can tell you, in the state of Texas, capital murder; in the state of Louisiana, first-degree murder, that's acting purposely. When we start getting to just murder or second-degree murder, then we're probably saying this person acted knowingly. Okay. And then when you look at manslaughter, it's either reckless or negligent, right? So, but look at it from other crimes too, like burglary, for example, and various other crimes you can look at. Where do we place the intent at? What's the category we use to charge someone or say that the particular crime they committed fits at this defense at a felony 1, 2, 3. I mean, we can go on all day about this. So hopefully this helped you a little bit when it comes to the intent. I mean, we can talk about this all day long. I can tell you, if I was a lawyer, and I'm sure lawyers would agree with me, that trying to show this, in terms of a crime and to formally charge someone is probably not easy. And here's the catch, and I'm going to mention this anyway, is this is where we as prosecutors, we may not be able to show that someone acted purposeful or knowingly, but maybe we can show that they acted recklessly, right? And then at that point, we can use that as a tool or leverage to get someone to plead guilty to a lesser charge. And why do I say that? Because normally that's what we do as prosecutors, okay? So the higher you go in terms of that intent, especially purposely and knowingly, you got to be able to show all these things, okay? Anyway, enough of me, running my mouth. Hope this helped. Let me know if you need anything, and don't get caught slipping. Thank you.